Okay, right. Good afternoon, students. Once again, welcome back to PLUTUS IAS. Right. So, in the last previous two sessions, we have completed till 2018 the polity 10 years previous questions. Right. Today, we will start from 2017 and we will try to complete till 2014. Right. So, just going into the questions directly, just let me remind you few more things. Along with the questions, you try to also focus on the number of questions that are being asked. And second thing is the areas within the polity, the areas from where the questions are generally being asked, and that thing. And also you keep an eye on the type of questions, whether the questions are analytical questions or they are facts-based questions. Facts-based questions. So try to have a good idea about these two things also. Right. So right, we will go into the questions. Right. In 2017, the first question is, consider the following statements. So another thing I want to remind you that before 2023, the dominant type of questions were like this. Consider the following statements. 2 or 3 statements will be given, and you from those statements you have to recognize what are the statements correct and what are the incorrect statements. So till 2013, that was the dominant form of questions, and you know very well, we have already seen this. In 2003, this trend has been put away, and there were another type of questions, another format of questions, and we have seen that two formats, different format of questions that are actually reintroduced, we can say, in the 2023 examination. Right. So kindly please keep this thing also in mind. Right. The question, first question in 2017, question is, consider the following statements. Right. Statement 1, the Election Commission of India is a 5-member body. So straightforward, it is an incorrect statement. It is not a 5-member body. It is a 3-member body. Right. So there are changes in the Election Commission among the members. When first it was a single-member body, later it was converted as a multi-member body. But in between, again it was converted to a single-member body. Now whatever we have, the mechanism is, it is a 3-member body. Chief Election Commissioner will be there, and along with him or her there will be other 2 election commissioners. So this is an election year, general elections are going on, so be prepared for these kind of questions, on the entire election process. Right. Second statement, Union Ministry of Home Affairs decides the election schedule for the conduct of both general elections and by-elections. So this is also fairly, on the face of it, you can say it is a wrong statement. It is not the Union Ministry of Home Affairs. It is the Election Commission of India. That, whatever the things are there, that is about the conduct of elections, everything will be done by Election Commission of India only, including the preparation of voters list. Everything from the declaration that so and so candidates have been won in the elections, and eligibility forms will be handed over to a certificate that they have been elected. So till that, everything is taken care of by Election Commission of India only. Right. Next statement, Election Commission resolves the disputes relating to splits, mergers of a recognized political parties. Yes, this is under the control of Election Commission of India. It addresses those kind of issues. Best examples, the recent episodes that have taken place in Maharashtra. Right. So everything is, if a party is being divided, so the election symbol, earlier symbol, it go to whom it should go to. So these kind of issues will be decided by Election Commission of India. So which of the statements given above is are correct? So statement 3 only correct. Right. Next question, second question. Which one of the following is not a feature of Indian federalism? So purely this is again a conceptual question. Which of the following is not a feature of Indian federalism? Option A, there is an independent judiciary in India. Right. So this is a federal aspect. Yesterday also I think we have got a question on the federalism. What is the essential feature of the federalism in India? So there will be a court. There will be a highest court which will decide on the disputes between the center and the provinces. So, and its autonomy also have to be protected so that it can give transparent and proper judgments. So this is a feature of federalism. Option B, powers have been clearly divided between the center and the states. Yes, this is also a feature of the federalism. There is a division of powers between the center and provinces. So constitution will be there. Constitution, within the constitution, the division of powers will be mentioned. Third, option C, the federating units have been given unequal representation in Rajya Sabha. Right. So this is, in the actual, proper federation, the federating units will have equal representation in the upper house, that is House of States also it is called. In our country it is called as Rajya Sabha or the upper house. In the USA it is called as Senate. So if you take the example of USA, there each state has equal representation in the Senate, that is upper house. Each state will send 2 senators to that house. However, in India, you know very well, we are following a modified form of federalism. It is also known as quasi-federalism. So we have representation of the states at the central level through the upper house, but the representation within that house is unequal. It depends on the size of the population of the particular state, and based on that population size, the number of MPs that will be sent into the Rajya Sabha will be decided. Right. So this is also a correct statement in the context of India. Option D, it is the result of an agreement among the federating units. So generally the federation will be formed like this. If we see, the best example is again United States of America. That federation has been formed with the agreement among the states. So once the American War of Independence is over, the 13 colonies, they have come together and they have formed the federation. However, that is not the case with India. So we have divided the entire country into provinces only because of the administrative convenience, or for the convenience of administration. Right. So the Indian Federation is not formed because of the agreement between the states. So this is an incorrect statement. Generally, if we see the federal feature, this will be a correct feature, but when it comes to India, it will not correct in the context of India. So correct option is option D. Next question, question number 3. Right. Democracy's superior virtue lies in the fact that it calls into activity which of the following? Option A, the intelligent and character of ordinary men and women. Yes, we can take this sentence. Democracy means involvement of people, whether it is direct or indirect. Next one is option B, the methods of strengthening executive leadership. So this will not go well with the democracy's superior virtue. So something it is irrelevant, not related to democracy. Next one is a superior individual with dynamism and vision. Right. It is not about a single individual. It is about all the individuals that are there in the country or state. Next is a band of dedicated party workers. Right. This is also incorrect. Yes, the political parties, they are part and parcel of the democratic system, but it is not only about the party workers. It is again about the each and individual. citizen or person of that country. So in all the statements, option A, first statement, goes well with the question. So correct option is option A. Next question, question number 4. Local self-government can be best explained as an exercise in, so this is also again a conceptual question. Option A, federalism, right. So I mean, somewhat it will explain local self-government. So federalism means there will be various steps in the various stages of the government. So local self-government becomes part and parcel of the federalism, but it is not the exact or best explanation of the local self-government. Option B, democratic decentralization. Yes, the very virtue of local self-government is democratic decentralization. I mean, decentralizing power and taking the democracy to the grassroots level. So, and also taking the administration to the doorstep of the people, taking the governance to the grassroots level. That is the essence of the local self-government. Next is administrative delegation. So this may look like the local self-government, but in practice it is not at all decentralization. Just you are keeping power within you, I mean at the top, and just you are delegating part-time, you are delegating that power to the local self-government. If you want, you can take it back. So this is not the correct explanation of local self-government. Next is direct democracy. Yes, direct democracy somewhat related to local self-government only, but it is not again exact explanation to local self-government. Direct democracy can be at any level, local level, provincial level, even at the central level also, right. So the correct option is option B, democratic decentralization. So you should be aware of these, like options like these also. All options are somewhere, I mean, to certain level they seem relevant also, but you should choose the exact 100%, which is the option which is fulfilling the condition 100%. You have to choose that option. Here you may confuse with the direct democracy. So there is a close relationship between the vocabulary that is given in the question and in the option. So please make sure that you won't confuse when these kind of options are given, close options are given. Right. Next question. Question number 5. Consider the following statements. Right. A constitutional government is one which, option A, or sorry, statement 1, places effective restrictions on individual liberty in the interest of the state and authority. Actually, in fact, this statement goes against the, we can say, the spirit of a constitutional government, right. So this statement is straight away wrong. It actually goes away against the spirit of the constitutional government. Next statement, places effective restrictions on the authority of the state in the interest of the individual liberty. Yes, this is the correct explanation of the constitutional government. So the powers of the government or state or executive are restricted in favor of the citizens, so that their liberty and rights can be protected. Right. So constitution in effective, it guarantees the rights of the people against the state. Right. So that is the concept behind a constitutional government. So correct option is option B, statement 2 only correct. Next question, question number 6. Question is, which one of the following objectives is not embodied in the preamble of the Constitution of India? So I think it is a straightforward question. Right. So liberty of thought, it is there in the Constitution. Liberty of thought is mentioned. Economic liberty, I think it is not mentioned. Liberty of expression, liberty of belief. So these 3 words are mentioned, and economic liberty is not mentioned. Right. So freedom of thought, expression, and belief. So if you are aware of the vocabulary all the preamble, all the aspects that are mentioned in the preamble, you can easily answer this question. So this is a straightforward question. Next question, question number 7. The mind of the makers of the Constitution of India is reflected in which of the following? Again a very straightforward question. It is resembled in the preamble of the Constitution. Right. Next question, question number 8. Right to vote and to be elected in India is a which of the following rights? So fundamental right, natural right, constitutional right, legal right. So it is a constitutional right. So if you entirely understand the election process in the Constitution of that is there in the Constitution of India, right? So it is a constitutional right. So at that time when the exam was conducted, so there was a huge debate that it is also constitutes the legal right. Some experts have opinioned that the right to vote is a legal right, but if you study the 11th NCERT book, it is a very good book. You will once you understand the entire concept relating to government, etc., elections, etc., you will come to an understanding that right to vote is a constitutional right. It is inherent in the Constitution of India. Right. So the correct option is option C, constitutional right. Next question, question number 9. Which of the following are envisaged by right against exploitation in the Constitution of India? Right. Right. So which of the following are envisaged by right against exploitation in the Constitution of India? Options are prohibition of traffic in human beings and forced labor. Yes, this is there in the Constitution. Abolition of untouchability. Sorry, one second. Abolition of untouchability. Yes, this is there in the Constitution, but it doesn't constitute in the right against exploitation. So untouchability is mentioned in Article 17 of the Constitution. It comes in right to equality part. Right to equality, not in the right against exploitation. Next is protection of interest of the minorities. Again it is there in the Constitution, but it comes in the right to freedom of religion. Or for that matter, you can also take it in the cultural and educational rights also. So somewhat it overlaps. Protection of minorities, cultural and linguistic not cultural minorities, religious and linguistic minorities. So only in the Constitution, only two types of minorities are recognized. One is religious minorities and the second one is linguistic minorities. So there is also a concept of cultural minority, but that has not been recognized in the Constitution of India. Please be clear with this aspect. So this either comes in the right to religion or right to cultural and educational rights. Next is prohibition of employment of children in factories and mines. Yes, this is part and parcel of the right against exploitation. So correct option is option C. Option statements 1 and 4 are only correct. Right. Question number 10. Question is, one of the important implications of equity in society is the absence of which one? Privileges, restraints, competition, ideology. So one of the important implications of equality in a society is absence of privileges. So it may seem somewhat confusing, but if you see Article 18, so if you are well aware of the Article 18, you will come to know about it. It becomes easy for you to answer this question. So what happened with the Article 18? Article 18 abolishes all the traditional titles that are existing before the independence. Like previously also, when we were discussing about the question relating to Padma Awards, we have dealt in detail in this. So all the traditional titles like Deshmukh, Jamindar, etc., all titles were there. They were privileging some people over the other people. Those have been privileges. So equality, that is absence of privileges to particular type of people. Right. Next question, question number 11. Right. Question is, which principle among the following was added to the directive principles of state policy by the 42nd Amendment of the Constitution? Right. So equal work for equal pay for equal work for both men and women. Actually, this is there before the 42nd Constitutional Amendment itself. We have an act also, the Equal Payment of Wages Act. It has been enacted around 1951-1952 itself. Right. Next one is option B, participation of workers in the management of industries. Yes, this has happened during the 42nd Constitutional Amendment Act. So the then Indira Mrs. Gandhi government was trying to usher in a socialistic pattern of society. So as part of it, this actually a particular subclause has been inserted in the Constitution of India to make this possible. Right. So as a part of it, as a practice now, whenever shares of the company have been offered in the share market, so first few days only the workers, they will be given the option to purchase those shares. So by this way we are trying to make the workers as part of the management. Right. So this is one way, offering shares first to the workers. Once that time slot is over, 2 to 3 days, then it will be open to public, to other, rest of the public to purchase the shares of that particular company. Next is right to work, education and public assistance. This is also there in the DPSP from earlier. Next is securing living wage and human conditions of work to workers. This is also there from the beginning itself. So right to work, education and public assistance, the best example to make this provision enabling. So we have brought in MGNREGA. So with this we have provided work as a right. Right. So before that work was just given by the government. It was not, it doesn't have the characteristic feature of as a right. Right. That is the that is about that option. Right. Next is question number 12. Question is, which one of the following statements is correct? Right. The statements are, rights are claims of the state against the citizens. So this is a completely incorrect statement. Actually the we can say reverse of this statement is correct. The rights are claims of the citizens against the state. That is the correct statement. Option B, rights are privileges which are incorporated in the constitution of a state. Right. Rights are not privileges. They come because it is the prerogative of the state to give rights to the people. Right. Rights are not privileges. Privileges are different. Next is, rights are claims of the citizens against the state. Yes, it is the reverse of the option A. So this is the correct statement. Option D, rights are privileges of a few citizens against the many. So this is also incorrect statement. Actually the correct definition is, if some people have been prioritized against many, that those are known as privileges. So rights are not privileges, and this statement is also incorrect. If rights are given to only few people, they become privileges. They are not called as rights. Right. So this is about 12th question. You will see many number of conceptual questions in the polity also. Next is, consider the following statements. Consider the following statements. The statements are, with reference to the Constitution of India, the directive principles of state policy constitute limitations upon legislative function, executive function. So you will see they will not constitute they are not limitations on the legislative function. Actually, they enable the legislative function, and also they are not restrict the executive function also. Again, the executive tries to implement the directive principles of state policy. So, you know, the DPSP are called as rights, but they are not justiciable rights. They are the rights in the other form. So it is the duty of the executive and somewhat the duty of the legislature to implement those rights that are there in the directive principles of state policy. Right. So these two statements are incorrect. So neither one nor two. So if instead of directive principles of state policy, if we replace this phrase with fundamental rights, then both statements become correct. So with the reference to Constitution of India, fundamental rights constitute limitations upon legislative action also, executive action also. So that is the nature of the fundamental rights, but not that of directive principles of state policy. Right. Correct option is option D. Next question, question number 14. Which of the following statements is or are true of the fundamental duties of an Indian citizen? Right. Statement A legislative process has been provided to enforce these duties. So this is an incorrect statement. There is no legal backing for the fundamental rights. So they are also not justiciable, just like the directive principles of state policy. Next is, they are correlative to legal duties. No, they are not correlative to legal duties. Right? So just they are duties. Only citizens of India, or for that matter people who are residing in India, they are expected to follow these duties, fundamental duties. That's it. They are not correlative to legal duties. Right. So legal duties are, it is a different concept. It is, the duties are innate, backed by a certain law, like providing compulsory military service. In some countries, there is a concept of legal duties, like Israel. So a person has to compulsorily serve in military for at least 2 years. So those are legal duties. So they are not, that concept is not there in India. So also no other aspects about the fundamental duties. So they were not there in the original constitution. They have added in the added by the 42nd constitutional amendment, etc., etc. Right. Right. However, there is another development also. A particular committee has been appointed to examine the fundamental duties. Right. So that committee has made several recommendations regarding the fundamental duties, and also that particular committee, actually I am unable to recollect the name of that committee. It listed some laws like national code, flag code, etc., and other the Forest Rights Act, Environment Protection Act, etc., etc. So Prevention of Civil Rights Act, etc. So the particular committee has listed several legislations, existing legislations itself, through which we can actually enable some legal backing for the fundamental duties. So please try to know about that aspect also. Right. Next question, question number 15. The question is, in the context of India, which one of the following is the correct relationship between rights and duties? Right. Option A, rights are correlative with the duties. Yes, this is correct explanation on the face of it. It looks the correct explanation of the relation between rights and duties. Option B, rights are personal and hence independent of society and duties. So this is an incorrect statement. Rights are not personal. Some rights are there, they are personal, but also there are rights because rights given to a group of people, society. There are some societal rights also. Right. Next, option C, rights not duties are important for advancement of the personality of a citizen. So this is also incorrect. Rights are duties are equally important, if not more, as the rights. Next option D, duties not rights are important for the stability of the state. So this is also an incorrect statement. Again I am saying the rights and the duties are equally important. So there is a concept, right? In a society, if I take a society, if the people have only rights and they do not have the duties, so this society will lead to anarchy. It will become an anarchical society. Let's suppose if in a society only there are duties and there are no rights, then this society will move towards slavery. So all the people at the end of the day, they will become slaves of the state, and the ruler, whoever is there, the government, it will become the only duties are there. It will lead to slavery, and here the person will become the head of the government. He will become monarch. So to avoid this kind of an equal blend, there should be an ideal blend of rights and duties. Then there will be harmony in the society. So everyone will enjoy their rights. Also, if I am following my duties, other person's right will be enforced. I mean realized, that other person can realize his right. So that is the beautiful relation between the rights and the duties. Okay. So correct explanation is rights are correlative with the duties. Next question, question number 16. Right. Consider the following statements. Statement 1. In the election for Lok Sabha or State Assembly, the winning candidate must get at least 50% of the votes polled to be declared elected. Right. So in the context of India, it is incorrect. So whatever may be the percentage of votes, so whoever gets the major votes, majority of the votes, that person is declared as elected. I mean, there is no need for getting 50% of the above 50% of the votes. Right. So the system, the present system which we have for Lok Sabha and State Assembly, it is called as FPTP, first past the post system. Right. So that system of election we are following. So where a person need to be declared elected has to score or secure more than 50% of the vote. That system is actually called as PR system, proportional representation system. We are following it in certain cases like election of the president, election of the vice president, and for election of the Rajya Sabha also, right, where indirect election is there, we are following some modified form of proportional representation, not the exact form of proportional representation we are following. But where the direct elections are there, like elections to Lok Sabha and state legislative assemblies, we are following the FPTP. Statement 2. According to the provisions laid down in the Constitution of India, in Lok Sabha, the speaker's post goes to the majority party and deputy speakers to the opposition. So this is happening, but it is happening only as a convention. It is not there in the provisions in the Constitution. It is not mentioned in the Constitution. We are following it as only a tradition. Right. So remember this, don't confuse. We are following that deputy speaker's position is going to the largest opposition party in the respective house, whether it is Lok Sabha or for that matter few state legislative assemblies also, but it is coming as a convention, not mentioned in the Constitution. So statements neither one nor two are correct. Next question, question number 17. Right. Which one of the following are not necessarily the consequences of the proclamation of President's rule in the state? Right. So first is dissolution of state legislative assembly. So yesterday also we have seen this question. So this will not happen automatically. So if the president wants, he can dissolve the state legislative assembly. But once the president's rule is imposed in a state, this state legislative assembly will be kept in a position that is called as suspended animation. Suspended animation means it will be there, house will be there, but it will not act, right? So the house will be in suspended animation. I mean, the house will not be dissolved, it will be there, but it will not have any functions to do. All the functions will be done by, and the functions will be transferred to Parliament, right? Next is removal of the Council of Ministers in the state. Yes, this will happen. So the very purpose of imposing the President's rule is to remove the existing government, that is the Council of Ministers headed by the Chief Minister. Next is dissolution of the local bodies. So this has no relation with the actually imposing the President's rule. The local bodies have not related with the imposition of the President rule. So this is also not a necessary consequence. So what is the correct option? Statement 1 and 3, they are need not happen once President's rule is imposed. So correct option is option B, statements 1 and 3. Next question, question number 18. Right. Question is, out of the following statements, choose one that brings out the principle underlining of the cabinet form of government. So cabinet, this question is about cabinet form of government, right? Option A, an arrangement for minimizing the criticism against the government whose responsibilities are complex and hard to carry out to the satisfaction of all. So it is by reading this part only you can come to the conclusion that it is an incorrect statement. It is not an arrangement for minimizing the criticism against government. So cabinet is a cabinet form of government. I mean, it is not the purpose of the cabinet form of government. Right. Next is a mechanism for actually first you should understand what is actually meant by cabinet form of government. So here I mean a portfolio of I mean the actual business will be divided into various portfolios. I mean in present language that can be called as ministries. Ministries. The business of the government will be divided into various ministries, that is also called as portfolios, and each ministry will be headed by a minister, right? So the important ministers, they are called as cabinet minister, right? So apart from that, for administrative convenience, we also have the deputy ministers and ministers of state also, right? That classification we will see for other time. Actually this system, it is called as cabinet system of government. Right. So this statement is straightforward. It is an incorrect statement. Statement B, a mechanism for speeding up the activities of the government whose responsibilities are increasing day by day. So it partially explains the cabinet system of government. Yes, this is to somewhat helps in speeding up the activities, but it is not the actual concept behind the cabinet form of government. Option C, a mechanism of parliamentary democracy for ensuring collective responsibility of the government to the people. Yes, so this is the actual conceptual theory behind a cabinet form of government. Alternatively, it can also be called as parliamentary form of government also, cabinet form of government. Alternatively, it can be called as parliamentary form of government, in which the cabinet is, or the ministers is, or the council of ministers is responsible or accountable to the lower house of the parliament, right? So they are accountable to parliament means what? They are indirectly accountable to the people of India, right? Option D, a device for strengthening the hands of the head of the government whose hold over the peoples is in a state of decline. So this is also a superficial statement, right? So what is the correct option? Option C is the correct option. Right, next question. Question is, for election to Lok Sabha, a nomination paper can be filed by option A, anyone residing in India. So this is an incorrect statement. A foreigner, if he is residing in India, that person is not eligible to file his papers. Also, there are age limits also, 25 years. That person should not be less than 25 years of age, etc. There are many other eligibility criteria is there. So the criteria is mentioned in the articles of the Constitution. Apart from that, we also have a RPA 1951, Representation of People's Act. There also certain again disqualifications mentioned, so that that persons also are not eligible to file the nomination papers. Option B, a resident of the country, is resident of constituency from which the election is to be contested. No, this need not be the case. If that person is registered, a registered voter in any part of the country, he can file nomination for any constituency, no problem with that. Next is a citizen of India whose name appears in the electoral roll of a constituency. Yes, this is correct. So that name, that person's name can appear in any electoral constituency. No need to be within that state, or for that matter within that constituency. He can be registered as an elector in any part of the country. No problem with that. Right. Next is any citizen of India. So this is also a very vague statement, because there are lot of conditions if that person still an Indian. So there are conditions like age criteria. He should be not less than 25 years. He should not be declared by a court as undischarged, insolvent, etc. So that should not be there. Office of profit, that one more condition is there. So there are a list of eligibility criteria, and RPA also prescribes some other conditions, like he should not be convicted for heinous crimes. He should not have been convicted for hate speech and promoting enmity among the communities, etc. There are several other conditions. Next question, question number 20. With reference to the Parliament of India, consider the following statements. Right. Statement 1. A private member's bill is a bill presented by a member of Parliament who is not elected but only nominated by the President of India. So this is an incorrect statement. Actually, what is meant by private member's bill is a bill introduced by a member other than a minister. Only if a minister introduces a bill, that bill is known as government bill or treasury bill. Apart from minister, any other member of Parliament, whether he is nominated or elected, or he is hailing from the same party which is in the power, then also it is called as a private member's bill. Right. Only if a minister introduces a bill, that bill is known as a treasury bill or government bill, public bill, or you can also call it as public bill. So statement 1 is incorrect. Second one is, recently a private member's bill has been passed in the Parliament of India for the first time in history. So recently means here it is the time period of 2017. So at that time no bill has been passed during that time. So only earlier period, first few decades of after we have adopted a constitution. So there the spirits were good. There was not that watertight division between the opposition of the government. So there was goodwill among the members. So few times, I think 2 to 3 times, a private member's bill has also become, it has been adopted by both the houses and they have become acts also. But after that you will see, actually recent example, only one example is there. Tiruchi Shiva, who is the MP from Tamil Nadu, he introduced a private member's bill about the transgenders. So no doubt now we have an act that is actually introduced by the government itself. But before that, he introduced a private member's bill on transgenders. But however, that bill has been not been passed by the parliament. My idea is that it is not even introduced. He tried to introduce that bill. I think it has not been accepted, I guess. So this is the story about the private members bill. So none of the statements given are correct. Next question, question number 21. The main advantage of the parliamentary form of government is that parliamentary form of government, repeatedly it is in the new it is among the questions. So I have already explained. Parliamentary form of government is the Council of Ministers headed by the Prime Minister. It is accountable to the lower house of the Parliament, that is Lok Sabha. So it fulfills the principle of collective responsibility. They sail and sink together. Right. Option A, the executive and the legislature work independently. So this is not the feature of the parliamentary form of government. It is not advantage also. Actually, the parliamentary form of system is adapted to enable cooperation between the executive and the legislature. So in the parliamentary form of government, the government emerges from the parliament, especially from the Lok Sabha. So the government is part, or it emerges from the some members from the parliamentarians itself. They are elected as ministers. Right. That is the, the philosophy behind the parliamentary form of government. So the executive hails from within the parliament, so that there will be a cooperation. The bill making or passing of bills or law making, which is actually the duty of the parliament or legislature, it is actually initiated and tracked or acted upon by the executive, which is actually the function of the legislature, but it is initiated and acted upon by the executive. Right. Next statement is, it provides a continuity of policy and is more efficient. So this is not a correct statement. Actually, we can say the opposite form of the parliamentary form, that is the presidential form. Presidential form, we can say it provides somewhat continuity, because in the parliamentary form of government, what happens, once that, the government will be in power until they have the support of the lower house of the parliament. Once they lose the support, let's say a no confidence motion has been passed by the parliament against that government, the government loses its power. So there is more chance for discontinuity, not for continuity. Right. Next is, actually this statement fits very well for bureaucracy. So actually bureaucracy provides continuity of policy, and it somewhat gives continuity whenever there is a change of government. The bureaucracy provides continuity to the governance. Next is, the executive remains responsible to the legislature. Yes, this is the characteristic feature of the parliamentary form of government. Executive means the Council of Ministers headed by the Prime Minister or the Chief Minister at the state level. Next is, the head of the government cannot be changed without election. So this is also incorrect statement, just now I told. So once no confidence motion is passed, another party, which the different party, let's say, which is there in the Lok Sabha, that party or a person claim to form the government if he achieves the support of the parliament when confidence motion is introduced, then that government can continue. So there can be a change of the government without conducting a fresh election also, right? So correct explanation for this is option C. Next question, question number 20, sorry, I think it is question number 22. All right. Right. Question is, the Parliament of India exercises control over the functions of the Council of Ministers through adjournment motion, question hour, supplementary questions. So all these are correct. They are tools in the hands of the legislature or parliament so that they can control. So apart from that, other mechanisms also there, passing of motions, including voting budget, many other options are there. Asking questions, 0 hour, many other tools are there, just go through them. Correct option is 1, 2, 3. Right. Question number 23. Alright. So question is, in India, judicial review implies which of the below? Right. Judicial review means the power of the judiciary to pronounce upon the constitutionality of laws and executive orders. Yes, this is the correct explanation of the judicial review. So articles, remember, remained Article 13 and Article 32. So from these articles, the judicial review power to the judiciary is given within the Constitution of India. Right. So next question. Sorry. So these are the questions in 2017. So fairly you will see the number 23. I think because of this reason only 2017 they have asked a lot many questions. So because of this reason I think in 2018 they have reduced the number of questions. They have made it around 12 or 13. So these kind of fluctuations will also be there. So try to be ready for these kind of, you can say, fluctuations. Also UPSC is known to create fluctuations in the patterns of examination, right? So next we will go to the year 2016, right? So first question in 2016, consider the following statements. Statement 1 is, the minimum age prescribed for any person to be a member of panchayat is 25 years. So this is an incorrect statement. Age is 21 years, right? So try to be aware of all the provisions related to 73rd and 74th Constitutional Amendment Act also. Next is, a panchayat reconstituted after premature dissolution continues only for the remainder period. Yes, this is a correct statement. Unlike the state or central governments, once, if a local body is dissolved, the next elected body, it remains for the, will be in power for the only remaining term of the first body, right? So let's say the tenure, actual tenure will be 5 years for all the local bodies. Let's say after 3 years, particular body, it has lose the confidence of the whatever the local body representatives are there. Again, elections are held and another body has been incorporated. Let's say a Jilla Parishad chairman has been, new Jilla Parishad chairman has been established, appointed. Apart from that, ZPTC, ZPTCs will be there and Jilla Parishad chairman will be there. So they will serve the term of the remaining 2 years only. They will not again serve the term of 5 years. So if you see the state government and central government, so if government, generally the term of the government will be 5 years. Let's say for 3 years a government is in power. After that it has lost the confidence of the Lok Sabha. Again elections have been held and another government has been elected. So that again elected government, it will serve for 5 years. So this is there. However, that thing is not there in the local self government. But you know, there is a lot of discussion going around the simultaneous elections. So one of the suggestions, so if at all the simultaneous elections will come into vogue, if they come into existence, So this same thing is going to happen with the governments at the state and central level also. So they will also, once the government loses power in between their prescribed tenure, the again newly elected government has to, only be there for the remaining term only. Then only the concept of simultaneous elections will go forward. Otherwise, it is next to impossible, right? So we will see whether that change will come or not. We will wait and see, right? So for purpose of this question, the statement 2 is correct. That thing is there in, at present there is that thing is there in local self-governments. Right. Next question, question number 2. Question is, which of the following statements is or are correct? Statement 1, a bill pending in Lok Sabha lapses on its prorogation. So this will not, the bill will not lapse if the house is prorogued, right? Next statement, a bill pending in Rajya Sabha which has not been passed by Lok Sabha shall not lapse on dismissal of the Lok Sabha. Yes, so a bill pending in Rajya Sabha which is not presented to Lok Sabha, it will pass, which has not been passed by Lok Sabha or not at all presented to Lok Sabha, shall not last on the dissolution of Lok Sabha. So this bill will be presented to the next of constituted Lok Sabha. So statement 2 is correct. So only statement 2 is correct. Statement 1 is incorrect. Next question, question number 3. I think same question has been reprinted. There is a mistake. Right. Next question. Consider the following statements. Consider the following statements. Statement 1 is, the chief secretary in a state is appointed by the governor of the state. Right. So the chief secretary in a state is appointed by the governor of the state. So here answer is actually the governor, formally the governor appoints the chief secretary, but in fact everything is decided by the council of ministers. So they will decide upon the appointment of the chief secretary. Next statement is, the chief secretary in a state has fixed tenure. So this is also incorrect statement. Generally, the chief secretary will serve, etc. Generally what happens, a person who has kind of reached his peak in his service, generally the IAS officer, senior most IAS officer will be appointed to the position of chief secretary, and this person who is appointed as a chief secretary, he will serve his remaining entire tenure as the chief secretary. He will not be removed. But further, if that person who is going to be appointed as a chief secretary, let's say he has only 3 to 4 months of service is remaining, and that person's tenure, once his retirement age comes also in between, that person's service can be extended up to 2 years. So there are specific guidelines given by Supreme Court that there should be some continuity in the administration, and for important positions, important posts, there should be some tenure, minimum tenure. So like that, till 2 years, the service can be extended. For the positions like cabinet secretary, chief secretary, the director of CBI, and the directors of ED, etc., wherever there are important positions, that can be done. And the first statement is also incorrect. So actually the chief minister appoints the chief secretary. So statements, statement 1 is incorrect and statement 2 is also incorrect. Next question, question number 5. The Parliament of India acquires the power to legislate on any item in the state list in the national interest if a resolution to that effect is passed by, this is the exclusive power of the Rajya Sabha. It passes a resolution by a majority of not less than 2/3 of its members present and voting. So then that becomes possible. So an item can be transferred to the Lok Sabha, and that item will be become eligible, which is actually mentioned in the state list, to be legislated upon by the parliament. And once that resolution is passed, that permission will be there for 1 year. That permission will be there for 1 year. So within 1 year, if parliament not acts on the resolution, once again whatever the resolution is passed by Rajya Sabha, that will become nullified after 1 year. Right. So I think very less questions are there in 2016. Very few questions are there. So be ready for these kind of fluctuations. So in 2016 and 2018, there are very few questions. Especially in 2016, there are very few questions, and you will see a spurt in the number of questions in 2017. Right. So now we will see the questions from 2015. I think there is a problem in the serial numbering. Right. So no problem, we will go forward with the question. So this is the first question. Question is, the provisions in the 5th schedule and the 6th schedule in the Constitution of India are made in order to which of the following? Right. Option A, protect the interest of the scheduled tribes. Yes, you know very well. It is a easy and straightforward question. They are made to protect the interest of the scheduled tribes. Next question, question number 2. Right. Question is, the fundamental object of Panchayati Raj system is to ensure which among the following? First is people's participation in development. Yes, this has been the one of the primary motives, to take administrative to the doorstep of the people so that people can take part in the administration. Next is political accountability. This statement will not fit political accountability, right? It will not fit into the system of Panchayat Raj institutions. Next is democratic decentralization. Yes, we have seen this before also. So one of the major objectives of Panchayat Raj system is to realize the goal of democratic decentralization. Financial mobilization, this will also not exactly fit into the Panchayat Raj system. So the correct options are 1 and 3 only. Next, question number 7. Question is, the ideal of welfare state in the Indian Constitution is enshrined in its straightforward and direct question, directive principles of state policy. Right, easy question. So here and now you will now and then you will be getting these kind of questions, very easy questions. Right, next question, question number 8. Right, consider the following statements regarding the directive principles of state policy. Again, question on directive principles. The principles spell out the socio-economic democracy in the country. Yes, this is a correct statement. So the DPSP, they are also called as socio-economic rights, economic or socio-economic justice. On the other hand, fundamental rights are for political, they are political rights. Right. So first statement is correct statement. Next statement is, the provisions contained in these principles are not enforceable by any court. Yes, this is also correct. Yesterday also, previously also we have seen, they are not justiciable. They are not enforced by the courts of law, and no person can go to court and ask that please enforce directive principles of state policy. Right. So statements, both of the statements are correct. Next question, question number 9. Right. Again, consider the following statements. Statement 1 is, Legislative Council of a state in India can be larger in size. The Legislative Council of India, the Legislative Council of a state in India can be larger in size than half of the Legislative Assembly of that particular state. So this is an incorrect statement. The Legislative Council should be approximately or around 1/3 of the size of the state Legislative Assembly. So this is a factual thing, try to remember that. So the Legislative Council should be approximately 1/3 of the size of the state Legislative Assembly. Second statement, the governor of a state nominates the chairman of the legislative council of that particular state. So this is also an incorrect statement. Actually, the members will elect the chairman of the legislative council. The members of the legislative council, they will elect their chairman. So this is also an incorrect statement. Correct option is option D. None of the statements are correct. Question number 10. Question is, there is a parliamentary system of government in India because Lok Sabha is elected directly by the people. So this is not the exact reason. Parliament can amend the constitution. This is also not the exact explanation. Rajya Sabha cannot be dissolved. This is also not exact explanation. Council of Ministers are responsible to Lok Sabha. This is actual explanation for parliamentary form of government. Right. Next question, question number 11. Consider the following statement. Statement 1. The Rajya Sabha has no power to reject or amend the money bill. Right. This is a correct statement. So previously also we have seen when it comes to money bills, the Rajya Sabha has not much powers. It cannot reject. It can not amend the bill. Only thing it can do is it can just delay the bill. Just delay the bill. That too only for 14 days. That too only for 2 weeks. Next statement is the Rajya Sabha cannot vote on the demands for grants. Right. This is also a correct statement. Demands for grants, it is part and parcel of the budget process. So those are also equal to money bill only. So just it can have a discussion on that, but it do not have the power to vote on that. Next is Rajya Sabha cannot discuss the annual financial statement. So same thing applies to annual financial statement is nothing but budget. Budget under Article 112. Right. So same thing happens for demands for grants also. So the Rajya Sabha can discuss, but it cannot vote on those two things. So statement 3 is incorrect. So correct option is option B. Statements 1, 2 are only correct. Next is next question. When a bill is referred to a joint sitting of both the houses of Parliament, it has to be passed by which of the below? Right. A bill is referred to a joint sitting of both the houses of Parliament. So joint sitting, you know very well, it happens under Article 108. So whenever there is a disagreement on a bill between the Rajya Sabha and Lok Sabha, one house approves it and another house rejects it. It happens only for the ordinary bills, not for the finance or money bills or for the constitutional amendment bills. So then the joint sitting happens according to the under Article 108. Then what happens? So it has to be passed by a simple majority of the members present and voting. Yes. So yesterday we have discussed this. So about the respective powers of Rajya Sabha and Lok Sabha. So when it comes to ordinary bills, at the end, though it looks like both the houses have equal powers, so because of the mechanism of joint sitting and the numeral superiority of the Lok Sabha, so almost to 200 members we have extra in Lok Sabha when compared to Rajya Sabha. So because of that numeral superiority, the Lok Sabha may prevail. So however, the bill has to be passed by a simple majority of the members sitting and voting, members present and voting. Right. Next question, consider the following statements. Consider the following statements. Statement 1. The executive power of Union of India is vested in the Prime Minister. Wrong statement straight away. It is vested in the Council of Ministers, or for that matter, actual de facto power is vested in the Council of Ministers headed by Prime Minister. So if you speak according to the Constitution legally, it is vested in the President of India. So President of India, he is head of the country and head of the, it is actually, if we go according to the articles, it is vested in the President of India. Statement 2, the Prime Minister is ex officio chairman of the Civil Service Board. So this is also incorrect statement. Actually, the Cabinet Secretary is the ex officio chairman of the Civil Services Board. So it is also completely facts-based question, especially the second statement. Right. So you should be knowing the something about the these positions also: cabinet secretary, chief secretary, attorney general, advocate general, solicitor general, etc., etc. So these are the constitutional offices. You should be aware of these things also. Next question, question number I think this is question number 8, like that in the series, right? Question is, with reference to the union government, consider the following statements. Statement 1, the Department of Revenue is responsible for the preparation of the union budget that is presented to the Parliament. Right, actually it is not the Department of Revenue, there is another department, Department of Financial Affairs, right? Department of Financial Affairs, there is another department. I think in Finance Ministry there are 4 departments, 4 different departments are there. This department is responsible for preparation of the budget that is presented to the Parliament. Next statement, no amount can be withdrawn from the Consolidated Fund of India without the authorization from the Parliament of India. Yes, this is a correct statement. Everything, I mean, it goes without the approval of the Parliament. No amount can be withdrawn from Consolidated Fund of India. This is a correct statement. Next statement, all the disbursements made from public account also need the authorization from the Parliament of India. So this is somewhat incorrect. Public account, it has some, we can say, flexibility for the government. So generally the revenue that is coming from the government departments like post offices, railways. So sometimes it goes into the public account. Also especially these 2 bodies, post offices and the Food Corporation of India also do some business, some work. So whatever the revenue is coming or loss, it is making loss. So those amount will be paid from public account only. So it need not always get the approval of the Parliament for disbursements from or into the public account. Right. So statement 3 is also incorrect. So option C, statement only, second statement is correct. Next question. All right. Question is, who or which of the following is the custodian of the Constitution of India? So there is a debate in the question. The Supreme Court of India, it is the answer given by the UPSC, but if you read carefully the Constitution of India and you study the Kant book, it is in that clearly mentioned is the President of India is the guardian of the Constitution of India. So still that debate is going on. Even in my opinion, the Supreme Court is the guardian of India, because whenever the Parliament tries to subvert the Constitution of India by doing different kind of amendments, it is the Supreme Court of India that prevents the Parliament from making such amendments by means of judicial review. It is there from the beginning, and also the other addition, that is basic structure doctrine. So the judiciary keeps on depending the Constitution of India. But if you see the legal language, the language in the Constitution, and also if you read the Kant book carefully, several times it is mentioned that the President of India is the guardian of the Constitution of India. So still we can say the debate is going on, right? So sometimes these kind of bouncers will also become, I mean confusing questions will also be there, whether where you will stuck with 2 options that 200% seem correct, right? Right. So however, the answer given by UPSC is Supreme Court of India, so we have to also go with that answer. Next question, question number 16. To uphold and protect the sovereignty, unity and integrity of India is a provision made in the which of the below? So directly you will see that one of the 11 fundamental duties that are there in the Constitution of India, Article 51A. So there the 11 fundamental rights are mentioned. So in that, that is one of the fundamental duties. Direct and straightforward question. So these are the questions. So here also you will see fairly less number of questions only, approximately I guess 9 questions are asked from the polity topic, right? So this is also comparatively a less number only, right? Next, we will go into the questions of 2014, last year, with respect to our discussion. Right. So, which of the tough question to begin with? Right. Which of the following are associated with planning in India? So, very difficult question, I guess. Finance Commission, it is, if you see the answer, it is said that it is not involved in planning. National Development Council, once upon a time it was there. I think it is not there now. NDC is the phenomenon of UPSC. Sorry, UPSC, not UPSC, UPA governments. When UPA governments were in power, they used to have a National Development Council. This they used to have certain social activists, etc., thinkers, academicians, etc. So that council was there. It was giving useful instructions to government with respect to certain bills. So all the bills that have come in the first tenure of UPA, that is UPA 1 period, like bills like MGNREGA, MG RTI, etc. These important bills, they have come in the because of the advice of NDC only, National Development Council. Right. So NDC was at that time in news. Sonia Gandhi was the we can say head of that NDC. Right. Because of that, it was there in news. Now it is not there. Next is Union Ministry of Rural Development. It is also not parcel of planning. Union Ministry of Urban Development. It is also not part. The Parliament. So it is. It is said that Parliament is part of planning in India. Maybe because it is one thing is it is approving the finances, and it is also approving the budget. So at that time the budget has to be classified majorly into two parts, that is planned budget and unplanned. So like that there used to be classification in the budget, planned expenditure, unplanned expenditure, like that. So maybe because of that reason this could have been part and parcel. Parliament can be part and parcel of planning. Still, if you want me to be frank, still I am having confusion with this question and answer given by UPSC, because somehow or the other all the ministries are also, they take part in the planning directly, either directly or indirectly. So still I am confused with this question. So right, so you have to face these kind of questions also in UPSC sometimes. Right. Anyhow, next question. Question is, in the Constitution of India, promotion of international peace and security is included in the directive principles of state policy. Yesterday also we have seen this question. So it is clearly mentioned in the directive principles of state policy. Next question. Question number 3. Right. Which of the following are the discretionary powers given to the governor of a state? So very easy and straightforward question. The question may look lengthy, but it is easy and straightforward question. Statement 1, sending a report to the President of India for imposing President's rule. Yes, this is a discretionary power of governor, where he will not seek the recommendation of the Council of Ministers headed by Chief Ministers. Appointing ministers, this is not his discretionary power, it is normal power. So he appoints those people or persons or whose names have been recommended by Chief Minister. Those persons only appointed by governor as the ministers. So it is not a discretionary power. Next statement, reserving certain bills passed by the state legislature for consideration of the President of India. Yes, this is a correct statement. This is the discretionary power of the governor. He can reserve bills which are pertaining to national interest, or the bill has a vast we can say scope, like disturbing the powers of the high courts, etc. The president can reserve that bill for the consideration of the president. Sorry, the governor can reserve that bill for the consideration of the President of India. That is the discretionary power. Next one is making rules to conduct the business of the state government. This is not a discretionary power. This is a general power. So the correct options are Correct option is option D, statements 1 and 3 only correct. Next is same question, same type of question. Consider the following statements. Right. A constitutional government is one which, so here it is a conceptual question, though pattern is same, but it is a conceptual question. A constitutional government is one which, statement A, places effective restrictions on the individual liberty in the interest of the state authority. So this is an incorrect statement. Right. Next is places effective restrictions on the authority of the state in the interest of the. I think there is some confusion. This question has been repeated previously. Right. So we will skip this question. Next question. Right. Consider the following statements. Right. Statement 1. The President shall make rules for more convenient transaction of the business of the Government of India and for the allocation among the ministers of said business. Yes, this is straight away mentioned in the Constitution itself. This is the power given to President of India. Next is all executive actions of the Government of India shall be expressed to be taken in the name of the Prime Minister. Straight away wrong statement. So it is not the Prime Minister, it is President. So if Prime Minister is replaced by President, then this statement becomes correct. So here only statement 1 is correct. Statement 2 is incorrect. Next question, consider the following statements. Right, consider the following statements regarding a no confidence motion in India. Right. Question is, there is no mention of a no confidence motion in the Constitution of India. Right. So exactly if you say the word or the process of no confidence is not mentioned in India, only these things are mentioned, that those things are the Council of Ministers headed by Prime Minister of India are collectively responsible to the lower house of the parliament, that is Lok Sabha. So the interpretation and everything due to the practices adapted from the British tradition, the no confidence and the confidence motions, etc., they have come into vogue. So it is a correct statement. Next is a motion of no confidence can be introduced in the Lok Sabha only. Yes, this is the special prerogative of the Lok Sabha. Actually, the Rajya Sabha do not have any relation with the no confidence motion. It can only move in the Lok Sabha. Right. So option C, both the statements are correct. Right. Next question, question number 7. Which one of the following is the largest committee of the Parliament? So you should know some information about the committees, parliamentary committees. Types of parliamentary committees. There are standing committees, departmental standing committees, and there are ad hoc committees. Departmental standing committees, there are 24. So they play important role in the budgeting process. They are kind of permanent committees. Apart from that, there are ad hoc committees also. They are appointed, as and when they are required, relating to specific matters, including consideration of the bills, etc. So here the estimates committee, it is the largest committee in among the parliamentary committees. So if I am not wrong, it is having 33 members in total. Right. 22 are coming from the Lok Sabha, and I think 11 are coming from the Rajya Sabha. I'm not sure with the numbers. Please recheck once again. But however, this is the largest committee, the committee on estimates. Right. Next question. All right. Question number 8. Which of the following is or are the function or functions of the Cabinet Secretariat? So again a question on the Cabinet Secretariat. 1. Preparation of agenda for the Cabinet meetings. Yes, this is done by Cabinet Secretary. Secretarial assistance to Cabinet committees. Yes, this will be done by the Cabinet Secretary. He will assist the Cabinet and Cabinet Ministers, and also the Cabinet committees also. Committees will also assisted by Cabinet Secretary or Secretariat. Allocation of financial resources to the ministers. So this is completely incorrect statement. They have nothing to do with the allocation of finances. Right. So statements 1 and 2 are only correct. Right. Next question. The power of the Supreme Court of India to decide disputes between the center and the states falls under its which of the jurisdiction. So it is not advisory jurisdiction. Advisory jurisdiction happens under Article 143. So when the President seeks an advice on a matter of fact or law, so only on these things the President can seek advice from the Supreme Court of India. That comes under advisory jurisdiction, not the not something related to disputes between center and state. Appellate jurisdiction, this is also not correct. Original jurisdiction. So one of the topics, or actually the original jurisdiction of the Supreme Court is, it is to act an arbitrant between the center on one side, states on one side, and the center on the other side. So that is the original jurisdiction of the Supreme Court. Apart from that, there are other two aspects also. One or two states on the, more than two states on the other side and the center on the other side, that will also come under the original jurisdiction of the Supreme Court. Apart from that, if there is a dispute between the two states, between the two provinces, then also that dispute comes under the original jurisdiction of the Supreme Court of India. Right. So writ jurisdiction, this is different. It comes under Article 32. Whenever the fundamental rights are violated, the Honorable Supreme Court can issue writs. That is the writ jurisdiction. Appellate jurisdiction is, it is the appeal against the judgments given by the lower courts, especially the high courts. That is called as appellate jurisdiction. Right. So correct option is original jurisdiction whenever there is a dispute between the center and the states. That is the original jurisdiction of the Supreme Court. Next question. The power to increase the number of judges in the Supreme Court of India is vested in which of the below? It is not with the President, it is there with the Parliament. So you will see many times in the history after the independence, the total number of the Supreme Court judges have been increased. So you try to also have an idea about the present day strength of the Supreme Court, right? So how many vacancies are there, etc., etc. You should keep these things in the mind. Right. So that is, it is the Parliament. The Parliament has the power to increase the number of the judges. Right. So with this we will be completing the 10 years questions of polity. Right. I hope somewhat you have benefited with this discussion. And tomorrow we will start the economic series, and in 2 to 3 sessions we will try to complete the economic subject also. Right. So this is it for today. Thank you. Thank you for joining the session. See you next time. Until then, have a good day. See you next time.